I want to talk to you about the complexity of employment law. In Australia, employment law is too complex. It's not properly accessible, and the safety net is weighed down by a mass of regulation. From 1 July 2009, the Rudd-Gillard Labor government introduced the Fair Work Act. As part of that, they introduced a new safety net. The safety net came into effect from 1 January 2010. It comprises the National Employment Standards and 122 of these documents called modern awards. What I'm holding up basically are the two books that Master Builders, books indeed, that Master Builders produces in order to explain the safety net. This book explains the Building and Construction General On-Site Award 2010. It's just over 200 pages. Without the explanation, the award is 140 pages long. That's just explaining a building worker's minimum entitlements. Then you've got the National Employment Standards, which operate together with modern awards to comprise the standard below which no one in Australia is permitted to be employed. The weight of the safety net is red tape, non-compliance, and difficulties in accessing it, which is why Master Builders produces these publications. What are we doing about law reform? What are we doing about making these instruments simpler and better able to be accessed by those people who need to use them? Well, in 2014, the Fair Work Commission, which administers these 122 modern awards, started a Modern Award Review 2014. It's going to go into 2016, and there is a great deal of litigation, That litigation is based on what are known as the Modern Award Objectives, which are set out in the statute, the Fair Work Act, which, as I said, was introduced from 1 July 2009. That litigation is designed, amongst other things, to make the awards simple and easy to access. So part of Master Builders' major program for 2015 is litigation, which will reduce this book, we hope, by half and make it much more simple. That's what Master Builders is doing in this space to try and remediate the safety net.